This is a re-recording of the Department's June 7, 2012 webinar, which has been edited. Good afternoon, and welcome to the New Jersey Department of Environmental Protection's On-Site Wastewater Management Unit's webinar to discuss recent changes to state regulations regarding on-site wastewater disposal systems and their impact on the real estate industry. My name is Mark Miller, and I will be moderating today's session with assistance from my supervisor, Eleanor Krukowski. Today's presentation is being recorded to be made available to the public online. If you miss any of the links or other information provided, it should be available shortly for you to review. I will be moving through the information quickly in order to address the questions submitted over the past few weeks as solicited through the New Jersey Association of Realtors. If we have any time at the end of the presentation, additional questions may be submitted electronically in the chat box on your screen. The Department has produced this informational session in order to specifically address rule amendments related to the real estate industry at the request of the New Jersey Association of Realtors. N.J.A.C has solicited questions, and the Department has done its best to address those questions as they relate to the rule. Regarding this adoption, all rule amendments are vetted through a statutory advisory committee that includes the New Jersey Association of Realtors. The advisory committee is required by law to also include the New Jersey Builders Association, the Title Insurance Association, municipal attorneys, professional engineers, and health departments. The department also brings in other stakeholders and private parties to focus on specific issues. The committee started working on these changes in 1999. The rule was proposed on March 7, 2011. And a 60-day public comment period commenced. In the end, 28 commenters submitted 220 different comments to the department. The proposal solicited comments through the committee, email advisories to over 450 email addresses, the New Jersey DEP website notice, and public notices in newspapers throughout the state. The official response to comments is published in the April 2, 2012 New Jersey Register. Official versions of the New Jersey Register and Department rules are available from LexisNexis. Unofficial copies are also posted on the Department's websites. So how do these changes impact realtors? These fall into two main themes. The first of which is the requirement for cesspools to be upgraded as part of real property transfers, regardless of their working condition. And secondly, the rules establish a state protocol for conducting inspections of systems during real property transfers. First, we will discuss the cesspool issue. The rules at 3.16, Other Sanitary Sewage Disposal Units, address the cesspool issue. Cesspools are not systems. Cesspools are units that receive untreated sewage that allows a direct discharge to the environment. Here is a picture of a cesspool for you to review. Cesspools were banned from new construction in New Jersey due to their negative impact on the environment on July 1, 1978. As you can see, the cesspool takes sewage directly from the home into a pit with open joints where the solids settle and the untreated sewage discharges into the environment. Systems have at least primary treatment, typically a septic tank prior to discharging. In this picture you can see there is a septic tank followed by a disposal field where water filters through the soil and then makes its way to the groundwater table. A conforming system is required whenever any correction is needed to a cesspool and at the time of real estate transfers, with limited exceptions. There are 15 of those exceptions, and we'll be discussing each one of them as they appear in the rule. The first is a conveyance for a consideration of less than $100. Second, a conveyance by or to the United States of America, the state of New Jersey, or any instrumentality, agency, or subdivision thereof. A conveyance encumbering realty or providing for the modification, release, or discharge of a debt, obligation, or encumbrance, or the foreclosure of a mortgage or lien, or sheriff and execution sales. a deed which confirms or corrects a deed previously recorded, a sale for delinquent taxes or assessments and the foreclosure of same, judicial proceedings affecting interest in real estate and documents filed in connection thereto, a conveyance by a receiver, trustee in bankruptcy, or liquidation, or assignee for the benefit of creditors, a deed eligible to be recorded as an ancient deed pursuant to the law, a deed or map that memorializes subdivisions of land, or which creates or affects easements or restrictions or other burdens upon title, a conveyance between family members or former spouses, execution of a lease or license, in specific performance of final judgment, a deed releasing a right of reversion, a deed by an executor or administrator of a decedent to a devisee or heir to effect distribution of the decedent's property in accordance with the provisions of the decedent's will or the intestacy laws of New Jersey or the passage of title by intestacy or descent, or a deed to effectuate a boundary line agreement. Any person claiming to qualify for an exemption shall document the exemption that applies by providing to the administrative authority the Affidavit of Consideration of Use, the RTF-1 form, available through the New Jersey Department of Treasury, and all supporting documentation. Can a home sale proceed if a cesspool hasn't been upgraded? The rule states that cesspools must be replaced as part of the transaction. The rule does not specify when or who completes the upgrade. The department did not want to discourage situations where a willing home buyer wanted to rehabilitate substandard property. The department understands that buyers will often be the responsible entity to perform the upgrade, but will not do so until they own it. In general, transactions may occur, but should be documented or conditioned so that all parties understand there will be no occupancy until upgrades are completed. It is important to discuss these options with your local administrative authority. Documentation could include contracts that finance property upgrades that stipulate this, signed agreements between parties and/or other conditions of the sale. The department is working with code officials so that certificates of occupancy requirements are withheld or conditioned upon upgrades. After the property is sold, health departments hold the current property owner responsible. However, in any of these cases, an engineering design should be done prior to the point of sale so that the buyer can see the cost estimates and they understand fully the cost associated with upgrading that cesspool. With regard to upgrading cesspools, you must upgrade to code if possible. However, if a licensed professional engineer can document a fully conforming system is not possible to the administrative authority's satisfaction, the same allowances provided in the rules are allowed to build a system as close to conforming, provided it is reasonable, or the installation of a holding tank. However, it's important to remember that the department has incorporated new advanced treatment technologies that provide many different options for the upgrading of these systems that now meet code. So there is some consideration by the administrative authority who has the ability to interpret the rules. They can determine when a conforming system is not possible what the potential options are for upgrading that system that are reasonable. There are also issues related to gray water cesspools that can be brought to code. Many of these instances involved old cesspools that were installed just to handle laundry wastes that didn't have a septic tank. However, if a septic tank can be added and that cesspool would now be a conforming seepage pit system, that allowance may be made by the local administrative authority. Another big issue that has come up several times is the issue of old two-compartment tanks where the second compartment discharges. These were often referred to as two-compartment cesspools. The health departments can require the immediate upgrade of them. However, even if they don't, these systems were often made of concrete block, which was not watertight, and is therefore considered malfunctioning under 3.4 of the new rule. In either event, you're still looking at fully upgrading that system. As discussed previously, there are new technologies that now meet code. These include advanced wastewater pretreatment devices, because it's easier to get rid of cleaner water than it is dirtier water. disposal options such as drip dispersal systems. However, there are trade-offs involved with using any of these newer technologies. These can often result in smaller system footprints or reductions in mound heights. However, all of these systems require maintenance at a minimum of twice per year for the first 2 years and at least once annually thereafter. Depending upon the complexity of the system, more than the minimum service requirements may be required. The next issue we'll discuss is septic system inspections. This is addressed in 12.6 of the rule. Inspections during real property transactions. These inspections are not mandatory under the rule. However, it is the state standard for doing these inspections. As the state standard, anything else must be defendable as to why the minimum requirements of the state standard weren't met. The administrator gets a copy of every inspection. Their response is only required when a report identifies a condition listed in the Health Department reporting section on page 4 of the form. Copy of the inspection form is required to the administrative authority within 10 business days. However, if one of those conditions on page 4, which represents a potential malfunctioning system, must be reported within 24 hours. The protocol identifies that any problems are negotiated between parties. There is no obligation of the administrative authority, other than issuing permits required for any work done to the systems. At this point, all parties should have the information necessary to properly negotiate the transaction. So when must an inspection follow the standard? This is required, including but not limited to, when an inspection is required by a law or rule, if a law is adopted to require the inspection of systems in the future, or if there's an existing law, such as a financing law, that requires the use of state requirements, you must follow the standard. If there is a local ordinance that's been adopted by the local Board of Health, you must follow those local ordinance requirements when you're in that jurisdiction. Also, when it's specified in a contract between the inspector and the person hiring the inspector. The department encourages those hiring system inspectors to specify using the state protocol in their contracts. Additionally, using the terms septic system inspector and septic system inspection has, when you're dealing with a real property transfer, has a regulatory implication. Since the term is defined by New Jersey rules, use of the term obligates use of the rule. Septic system inspectors are not engineers or soil evaluators. This is why the protocol does not require the inspector to evaluate whether there's an appropriate zone of treatment beneath the disposal area. If the inspector happens to be a licensed professional engineer or a qualified soil scientist, they may do this as part of the inspection, but it is not required by the protocol. Inspectors evaluate systems based upon available records and what is existing. If health department records are available, they must be reviewed by the inspector. Anyone can get them from the health department, but the inspection is not complete without completing that review. Inspectors determine the current working state of what is present. They are not there to guarantee future system functionality and do not establish whether there is a regulatory malfunction or failure that requires a response. The septic system inspection protocol has existed since 2003. The protocol has been published guidance in New Jersey, but is based upon a Pennsylvania Septic Management Association inspection criteria that was established in 1989. It is a professional standard recognized by the state. If it doesn't follow the minimum requirements of the protocol, it is not an inspection as defined by New Jersey rule. New Jersey one call is New Jersey law. It protects the utility, the water, the phone, and the cable systems, and human health from accidental electrocution or gas line explosions and other hazards associated with working around subsurface utilities. That is why New Jersey one call is required. Pumping all tanks is required as part of every inspection. You cannot inspect a tank below the liquid level without pumping. For example, here is a picture of a septic tank. There is no way for someone to see beneath the scum, the wastewater level, or to the sludge to determine if the bottom of the tank has been compromised or or cracked or in the sidewalls below those liquid levels without pumping those tanks first. The protocol is in Appendix E. Specifically, Condition 4J requires all tanks be pumped in order to consider the inspection complete. However, when the tanks get pumped depends upon observations at the time of the inspections. In some conditions, you don't pump the tanks right away so that others may observe the problems associated with the tank. So what is the health department role during these inspections? They are there to receive copies of all inspection reports. Again, this is required by the standard. Any report of a problem identified on page 4 of the inspection report results in the same response as they would any other report of a potential malfunction. That does not mean they must visit the site. They follow their standard operating procedures, how they would if they received a phone call or a complaint from a neighbor regarding a potentially malfunctioning system. Any repair or alteration to the system must be properly permitted by the administrative authority. You cannot do any work to a system without a permit. If a malfunction is confirmed by the administrative authority, the system must be repaired or altered. A conforming system upgrade is required if it is possible. If documented that no conforming system is possible, the authority may allow a non-conforming upgrade. If no reasonable system is possible, holding tanks are required. Malfunctions that are identified by these inspections include ponding or breakout of sewage or effluent on the ground surface, sewage or effluent seeping into buildings, backup of sewage into the building that is not a physical blockage of the plumbing, or leakage of watertight system components such as the septic tank or a distribution box or a pump tank. This does not include the high water condition or the potential for the lack of a zone of treatment. These are typically more investigation is necessary. The high water condition means that the system is nearing the end of its serviceable life. For example, if you had a 15-year-old roof installed on a house and the house is now 17 years old, you're most likely looking at an upgrade to that roof. Regarding the zone of treatment, inspectors are not always professional engineers or soil evaluation. They may note this as a concern or more investigation is necessary if there are mounted systems in the area, wetlands are observed nearby, or surface waters are located at or near the same elevation as the level of infiltration or the expected zone of treatment. That concludes our presentation. Now we will address the questions that were previously submitted to the New Jersey Association of Realtors and given to the department ahead of time to address. Question 1. How can the property owner comply with the new requirement to upgrade from cesspools where a prohibition exists in other laws or regulations, such as those in the highlands or pinelands, or in close proximity to C1 waterways? Question 1 and question 2 have a very similar answer, but they are similar questions, so we're going to move to question 2. Is there an exemption for historical properties, such as those that are over 100 years old and are located in environmentally sensitive areas? For example, how do you upgrade a cesspool where the DEP's own regulations will prohibit any soil disturbance? In response to questions 1 and 2, the department rules have exemptions or methods of permitting the upgrading of on-site wastewater disposal systems, especially when you're dealing with a repair or alteration to correct an existing malfunctioning system or upgrading a cesspool. Expansion of flow would be prohibited, and changes of use may be severely limited. However, continued use of an existing structure is often allowable. This may require the use of alternative or advanced treatment technologies. Technologies that can be located inside of structures to minimize soil disturbance outside, and drip dispersal systems where there is no fill brought onto the site are often options in these cases. A holding tank is the least desired and last option that we consider in these circumstances. Question 3. Who is going to pay for the upgrade of a cesspool when the lot size is minimal and the occupants are already below the poverty level? The answer to question 3 is that the law requires and the rules establish what meets the requirements for adequate sewerage utilities. By requiring upgrades at the time of sale, money can be made available through financing alternatives. there is some financial assistance that may be available through Department of Community Affairs Community Development Block Grants or the United States Department of Agriculture Rural Development Housing Grant Program. Some of these funding programs are limited to seniors, disabled persons, and very low-income families, though. For more information on these programs, here are some helpful links. I'm going to leave this slide up for a moment so that you will have time to access these links. Question 4. What is a homeowner that lost equity and does not have the funds to change from a working cesspool supposed to do? Assuming this question relates to a real property transfer, you should negotiate with the potential buyers. You can also discuss options with the administrative authority, such as the local health department officers. Transferring the property with no occupancy until the new system is installed is certainly an option. There are also options involving renovation loans where there's a contractual obligation to upgrade that system in a certain amount of time. There may be other legal agreements or Board of Health resolutions that the administrative authority may find acceptable in order to complete those transactions. Question 5. Has there been discussion with mortgage companies about mortgages not being approved on properties with cesspools until after the work is completed to upgrade a cesspool to a conforming system? Yes, certainly. We've had contact with a number of different mortgage companies and financing institutions. Slide 14 discusses the possibilities, given local authority oversight for transactions to proceed, provided that the new system owner can demonstrate a clear legal obligation to upgrade the sewage utility in a limited time frame. This does require that an engineering design be completed and approved so the potential buyer understands the costs that they are assuming. Renovation loans often include specific timeframes that must be met and can be used by the administrative authority to justify allowing the transactions to proceed. Question 6. Regarding foreclosures and short sales within the state, if a passing septic system inspection cannot be obtained for mortgages, are the banks planning on cooperating with state-mandated repairs? Do we have a system in place to demonstrate to the banks the need for their cooperation? Corrections are only mandated when there is a regulatory malfunction or if there is a cesspool. Unsatisfactory conditions or concerns beyond a regulatory malfunction are subject to the negotiation between buyer and seller. With a regulatory compliant inspection, the parties will have all the information necessary to properly negotiate the transaction. Again, this is similar to the 15-year roof on a 17-year-old house. There is no system in place with the banks. As before, they decide what to finance and what not to finance. The department has no control over that issue. Question 7. If a new system was installed 3 years ago and the house is sold today, can the same septic person who installed the system do the inspection of that system? How much is the inspection going to cost, and what costs could be involved? Well, the rules do not identify or limit who can do the inspection of a septic system. But if the client would have to identify for themselves if there is a conflict of interest concern. Fees are also not set by the rules. This will vary depending upon the conditions encountered on each property. All tanks of every system will be required to be pumped eventually for the inspection to be complete. Additional costs could include excavators, video scoping equipment, radio tracers, or any other specialized equipment needed to access or inspect the system components that are present on the site. Question 8. Are there different sets of criteria for inspections based upon the age of the property? For example, one that was constructed 10 years ago as opposed to a property constructed 30 years ago. There is only one protocol for system inspections in the rule. However, the protocol includes a methodology that encompasses systems dating back to 1954, which is the first law adopted regarding on-site systems in the state. It will also address many systems even predating that, depending upon what is involved with the components that are present on the site. Question 9. Are the requirements in this regulation for the upgrades or septic inspections the same for different types of properties residential versus commercial, industrial, or farm properties? That's a really broad question. System inspections from a baseline perspective are generally the same, but based upon what exists on the specific property. Requirements for upgrades are based upon the sanitary nature of the wastewater, except for food service, which, for example, food service facilities must incorporate grease removal and high-strength wastewater pretreatment in accordance with the rules. Non-sanitary discharges, such as industrial waste, are prohibited unless an N.J.A.C permit, which is a state operating permit, authorizes that discharge specifically. Question 10. If a local authority determines that a conforming system can be installed on a property, and the property owner does not agree, is there an appeal process where the decision can be challenged either to the county or a state entity? That's a very legal question, and I'm going to provide the legal response, which is appeals to determinations made by local health departments must be made directly to the local Board of Health having jurisdiction. Appeals of Board of Health decisions must go to a court of competent jurisdiction. Question 11. Can there be more stringent requirements locally? The answer is yes. The rules do allow local administrative authorities to adopt more stringent ordinances. The locals can also interpret the rules, and the rules are minimum requirement. Question 12. Will the rules affect commercial properties, and if so, how? The rules apply to any non-single-family residential application with estimated volume of sanitary sewage less than 2,000 gallons per day, in addition to the single-family residential properties. So they affect those commercial properties equally. However, if you cannot comply as a commercial property with the rules at 7:9a, you are required to obtain a state operating permit under the N.J.A.C rules, which are 7:14a. We did discuss this in a previous question. Now we will take some additional questions that are submitted live during the webinar. From the Camden County Health Department, Loretta Blake asks, how do we enforce inspectors submitting inspection reports? Well, the answer is, you really don't. The submission of inspection reports is required by the rules for people who are conducting conforming inspections with the rules. If you fail to report to the health department the results of an inspection in accordance with those rules within 10 business days or 24 hours if there's a potentially malfunctioning system, as indicated on page 4 of the inspection report, then you are violating the standard and you are subjecting yourself as an inspector to the liability of not completing a conforming inspection with your client, and therefore they may have legal recourse against you. The second question we received was from a Joan Yowell. If a septic system was installed 3 years ago, will it pass an inspection? The answer to this is that it depends upon what the inspector observes at the time of inspection. We've seen many cases where systems fail very quickly in less than 6 months due to the installation of garbage grinders, where the system was not designed to incorporate one. In those cases, septic tanks are oversized as well as disposal fields. If they're not sized appropriately, you will cause the system to malfunction prematurely. Additionally, one of the most common things that happens during a real estate transaction is that the new home buyers have the house painted. A lot of painters will dispose of their waste down the sink and into the septic system, which is not an appropriate use of a septic system. This paint will congeal and clog in the system and cause the system to fail prematurely. And certainly, if that was done 3 years ago, you could see a malfunction occurring. The last question we received during the live webinar was, does the department have a list of the inspection requirements? As discussed in one of the slides, Appendix E has a list of all the requirements of the protocol. This Appendix E is the second to last appendix in the rule, so it's towards the end. The final appendix, Appendix F, is the 4-page inspection report if you'd like to see a copy of that. That concludes our webinar. Our last slide is, how do we contact the New Jersey DEP if you have any additional questions? Here is all of our contact information. Please remember that this presentation will be made available online in the future for interested parties to review in case you missed any of the links or other information included. Thank you for watching this webinar presented by the On-Site Wastewater Management Unit of the New Jersey Department of Environmental Protection.